Hello and welcome to today's Euractiv debate supported by Qualcomm. We're talking today about the future of standard essential patents and innovation in Europe. And of course, we will be focusing in on that proposed regulation that's come from the European Commission and is being debated here in Brussels on standard essential patents. My name's Jennifer Baker. I'll be your moderator today, helping to put your questions to our great panelists. We will start with an opening intervention from Richard Vary, and then we will go into our panel discussion. When we're doing that, please do feel free to use Slido to ask your questions. Those in the room, please get out your smartphones. You should be able to find the QR code around on the walls. And for those joining online, of course, you can find the box on your screen. So please do put your questions to our panelists. I'll get them all in real time so we can try and get as many of those covered in the time we have available. So, with that, I am going to hand over the floor to Richard Vary, who is a partner at Bird & Bird and has been working on standard essential patents for around 20 years, so knows a thing or two. Richard, over to you.
Thank you. Good morning. This morning I have come from London, where things, I have to say, are looking pretty good. It's not raining. Boris Johnson has not appeared on our televisions for at least a month. And the Christmas lights are up. It is all looking beautiful and pretty, and we're all getting excited for the holiday season. 30 years ago, I was not having quite such a good Christmas. I was an undergraduate at Cambridge University. I was working as a project on water-based gloss paint, the development of this new technology that was going to revolutionize decorating. And I was fully expecting, when I graduated the following summer, to go and work for ICI, the UK's chemical company, in the laboratories carrying on with this project. But it was not a good time for the UK economy. We had interest rates at about 12%, and ICI, it turned out, was in some financial trouble, and my job was not going to be offered to me when I left. So instead, I found myself that Christmas sitting in the office of Linklaters, a law firm in London, working out how to break up the company that I was supposed to be going to work for into two parts: Zeneca, the profitable life sciences pharmaceutical part, and legacy ICI, the unprofitable heavy chemical part. Every cloud has a silver lining, and the silver lining, it turned out in my case, was that lawyers are paid an awful lot better than engineers. So that launched me onto a career that was perhaps rather better paid than I would otherwise have been. Why is that, though? Why do we pay engineers so badly in Europe? 20 years ago, that point was really hit home to me when I joined Nokia for the first time. And when coming to recruit more lawyers to start doing this SEP litigation that we had just started on, I discovered that I was having to offer salaries roughly twice that of what Nokia was paying its engineers. And it's a curious feature of Europe. You see, in China, you could have a perfectly good long-term career as an engineer. In the United States, the engineers are positively well paid, and there are plenty of Apple engineers driving around in Aston Martins. So what is it about Europe that makes it a relatively bad career choice? The answer is, I think, that it's a question of policy. You can set the dial, you can set the slider somewhere in favour of innovation and of rewarding our engineers, or you can set it more in favour of the consumer. Ultimately, engineers are paid by one of two routes. Either we pay them from the price of the products that we buy, or we pay them through our taxes when we subsidise technological development. In Europe, we don't subsidise technological development. Some countries do, we don't. So it comes down to where we have set the dial in terms of how we reward innovation and how we reward technological development, and the prices our consumers pay for the products that we buy in our shops. It probably makes sense in a relatively developed economy to set the slide more towards the favouring the consumer. We have done most of the development we need to. We live relatively well compared to many other countries in the world. So you can see why we have made that choice. But the consequence of that choice is that the short term benefits the consumer, and the long term, the development of new technologies, is in one direction. And we shouldn't be surprised then when other countries overtake us in terms of development of technology. 10 years ago, Christmas, this was again reinforced to me when I was at Nokia, and I was clearing up after the exit from Nokia in the mobile phone market. Now, that was, in retrospect, a real signpost. This was the last of the European mobile phone manufacturers. Ericsson had already quit, Bosch, Siemens, Alcatel had all stopped manufacturing mobile phones. Nokia was the last vestige of this, and Nokia had shut that down. That was a surprise because Europe had been at the forefront of developing this technology. SEPT, ETSI, this was the thing where we had led the world. Briefly, in a technological window, we had the world-beating technology, and in 10 years it had gone. Today, another decade has passed. Today, we are at another inflection point. Partly the SEP regulation, also the UPC. The UPC, there is no doubt, is a fantastic advantage for cellular standard essential patents, the ability to bring a single action much more cheaply than the United Kingdom, covering a much wider area than Germany. It is more efficient. It is a better way of dealing with our disputes than we have to date. So that moves things in one direction. The SEP regulation, people have different views about. What I do observe is that most of the people who are proponents of it tend to be the people who are not the patent owners, and the people who are opposed to it tend to be the patent owners, those who employ the engineers who do the standards development. So that suggests to me that the SEP regulation may be moving the slider back in the other direction again. Why do we have it? The perception seems to be that there has been too much litigation around cellular standard essential patents. Now, I'm a litigator of cellular standard essential patents, so I think that's a good thing, but there are others I perceive who disagree. But the truth is, the problem is not with cellular. Cellular is yesterday's problem. Today, we can value pretty much what any handset manufacturer should be paying to pretty much any SEP owner to within a cent or two. We can do so because the information is available, the method of calculation is known, and because we have this register of patents at ETSI, which can, with cleaning up, admittedly, be used pretty much to determine who owns what. We are in a pretty good place in terms of cellular. Today's problem is the newer standards. Why do we have all of this litigation with cellular? You probably saw the slide that we had outside. It's not lack of information. It is primarily due to competition. We have handsets which are priced to within €1 in order to compete with each other. Whether a mobile phone, an operator, ranges Oppo, Xiaomi, Samsung in its range that month depends very much on what the price is. And if you go into a Phones for You or a Carphone Warehouse or one of those types of stores, one month you will see a very different group of phones ranged to another month, and that's because it is so sensitive to price. These Android phones are competing to within the nearest euro on what they can sell their phones for. Apple is in a separate market, that's fine. We've all got iPhones, we all pay $1,300 each time we want a new one. That is a different and unique market, but Android is competing fiercely on price. And so those Android producers have to watch every euro very carefully. And as a result, they have to negotiate very hard with the patent owners. The patent owners are stuck. They are trying to recuperate their cost of investment, and they won't succeed. If you look at some of the numbers that are bandied around, the large SEP owners have spent hundreds of billions developing cellular technology, and few of them are earning revenues of even $1 billion a year in terms of recouping that investment. So that's a 1% rate of return on investment. Nobody is going to make that sort of investment at that sort of rate of return. And so it's going to be quite difficult for them to fund the next generation. They've got the siren voices in their ears of people saying, we'll buy your patents from you. Investment funds who need investment opportunities, who want to buy cellular SEPs, so they're trying to tempt them to sell the patents out. You've got the pools who are stuck in the middle. They're trying to solve this problem. The SEP owners need them to charge more because they're not recouping enough on their investment. The implementers need them to charge less if they're going to take a license. So the pools, the Avances of this world are torn in the middle between this difficult position. And then we've got the IoT chain on the right of my diagram. The IoT chain has another huge difficulty. You've got the OEMs who are buying a unit. They expect everything to be priced into it. The sellers of the unit haven't priced in royalties to it. They're stuck. They can't add 5, 10, 20 euros onto the price of a component because they haven't priced it in over their sales over the last. They can't pass it down the chain because the sellers of the modules to them also haven't passed it in. But IoT is only a tiny part of the problem. Most of the revenue is handsets, except down in this bottom right-hand corner, streaming. Today, with all of the subscriptions my children seem to have taken out, I seem to pay more for streaming than I do on handsets. When I add up my Amazon, my Netflix, my Disney Plus, my Apple Plus, all of those things that are now sitting there on my television, I am paying quite a lot in streaming revenues. And streaming is a technology that has been enabled by compression, video compression. This is a new standard. This is a new area of interest. Unlike cellular, we have no idea how to value streaming. How do you do it? Is it per subscriber? Is it per megabyte? Is it just some lump sum paid by the Amazons of this world? It is, what is the cost benefit to them of being able to compress this video by a certain amount? This is all an area where we are struggling to work out. And even if we do work it out, how we allocate that between the patent owners, we have no idea. There is no register like there is of Etsy. It is very hard to work out who owns what in terms of H.265 patents or AV1 or VP9 or any of those video compression algorithms we're using. The same is true of Wi-Fi. There is no register. There is quite a good business to be made by law firms like Bird & Bird in defending manufacturers of connected vacuum cleaners who get yet another letter through the door saying, please pay me 25 cents per vacuum cleaner for my fantastic Wi-Fi portfolio. It's very difficult to work out who's got what. So there is a problem that needs solving. The problem is not cellular. Cellular is yesterday's problem. If and where we can help industry, as a legal profession, as courts, as regulators, it is new standards, new technologies, working out what even is the mechanism, how do we even calculate these amounts? And that's where I think we should be focusing our attention. Thank you.
Thank you very much indeed, Richard, for setting the scene for us and sharing that very funny slide with us that I think we're all going to take a little bit of time to read after our panel discussion. So let's move on to the discussion. I am pleased to have joining with me today Marcus Kitja, who is the Legal and Policy Officer in the IP unit of DG GROW within the European Commission, and before that in various DGs of the Commission, including trade with an international aspect of IP focus. So please, Marcus, if you can join me here. Thank you very much. We also have Adrián Vázquez, MEP, Vice Chair of the AFCO Committee and the former Shadow Rapporteur on the EU SEP regulation. Thank you very much. Klaus Grabinski is Judge, President of the Court of Appeal and Chairperson of the Presidium of the Unified Patent Court. Michael Fröhlich, Director of Patent Development and IP Lab at the European Patent Office, also joins us here in the room. And joining me online, thank you very much, we have Andras Jokuti, who is serving as the Director of the Patent and Technology Law Division at WIPO since 2022, before that active in University Tech Transfer and used to be the Legal Director at the Hungarian Intellectual Property Office, so well versed in all the subjects we're talking about today. Marcus, I'm going to let you kick it off. You can respond to what you heard Richard saying, but give us your opening remarks and the lay of the land as you see it.
Yes, thank you. Thank you for inviting me and being able to speak also with the faces that are quite familiar in this setting. I just wanted to connect with Richard's introduction and use the picture of the slider, and so the intention of the Commission is taking the slider is not to move it in one or the other direction. Is it a SEP holder or an implementer? The Commission's intention is to use the slider and to turn on the lights on the SEP licensing ecosystem, which suffers from a lack of transparency, and this lack of transparency creates a multitude of problems, which the Commission aims to address with the SEP regulation. First, it's the lack of information on ownership of patents, as Richard already mentioned, who owns which standard, how many SEP holders own standard, how many SEP holder will then appear at the door of potential SEP implementers. Then the question arises, which of those patents then are in reality essential? If we take some studies that have been made on essentiality rates of 5G or 4G portfolios, the rate is somewhere between 70, 50, or even in some instances below 50%. So if we take then this as an indicator, then there is a problem with essentiality. And there is, of course, the problem of protracted, expensive negotiation and litigation. And in the end, it is the front rate that the parties want to agree on. And the current problem with jurisprudence is that it's not really well suited to solve or to give the answer what is really friend. Courts decide on injunctions, and very well so, but this doesn't lead to the resolution of the problem. What is friend? How much do I really have to pay? And these are the problems that the regulation, as I said, aims to solve, to bring more transparency into the ecosystem, and thereby, with more transparency, also increasing innovation to bring forward participants to be more active in licensing on both sides.
Thank you. Adrian, I know your role has changed a bit, so tell us what your current focus is with regard to the regulation.
Well, first of all, thanks a lot for the invitation. It's a pleasure to be here. And before starting, I must underline that I'm here in my capacity as former shadow of the dossier, and in the previous term, and the rapporteur. I'm sharing the group with the rapporteur, my dear colleague Marion Walsman. Therefore, what I'm going to say is my opinion, which gives me a little bit of freedom when it comes to discuss this file. I was listening, Marcus, and the Commission, and not only I want to focus on the process and what kind of legislation is needed to actually regulate SEPs, but also how we do that regulation. It's really important to understand that sometimes, at least as a legislator, when I start a dossier, the first thing I ask myself is this regulation needed? Is there any real purpose behind it? And is there a public demand on it? So I remember when we started looking to the file, and while I completely agree with the overreaching goals of the Commission when it comes to trying to solve some issues, like the transparency issue that you just mentioned, which I agree, there were other ones that I didn't actually fit much with my research as a rapporteur, as a shadow rapporteur, because at the end the goal was, for instance, helping SMEs across Europe to try to have easier access, to eliminate the possibility of litigation, and that I understand. But then when I start researching and asking, I didn't find any SMEs that they were actually demanding such change. So when you start having this, you understand the purpose, but you don't find the public demand on it, I start asking myself what was the real goal of the proposal as it was. And now we see that at the Council level, no one is willing to continue. And I hate to use the "I told you so" sentence, but it's what I said during the previous mandate when it comes to this piece of legislation. And I said that to previous Commissioner Breton. I told him, I don't see the goal in this, I don't see the purpose, and I don't see what are we trying to do this. And moreover, we were trying to do this in 6 months. Being such important issue, and not only for European companies, but when it comes to international allies that we have. So, and I finish. That is why I not only want to talk on the legislation itself, but on the proposal. And then I want to raise again that the Regulatory Scrutiny Board, which is this entity within the Commission that somehow deals on what is the impact that some pieces of regulation can have in society, in European society, let's say that this regulation did not pass it. It had a red light on it, which is one thing that as legislators we have to see closely. And that is why, with all the process, I think that when it comes to do pieces of legislation that could have such an impact in European companies, when there is not such a public demand, first of all, 6 months is not enough. It's not enough. And second, what we did is a really fragile attempt, because now it's blocking the Council. So what are we going to do? Start over again? It's going to stay there blocked for 10 years? So in Spanish, we have a say, which is basically what I tried to mean is we did a sandwich with nothing in the middle. And I think that's what we did.
I think pretty much everyone here would agree that 6 months is a very short time frame for any piece of legislation to pass through the Brussels sausage-making machine. But I think you're right. In this particular instance, probably a bit too ambitious. Klaus, your opening thoughts on what you've heard so far?
Yes, I'm a judge from a European Patent Court. And what is important to me is that people who think they have a case can bring the case to the court. So access to justice, that's an important aspect. And I'm a bit worried with regards to the SEP regulation, the draft, that it has an impact on this aspect, which is protected by the Charter of Fundamental Rights. And why so? Because before going to a court, if this becomes the law, the SEP owner will be required to first start a friend determination proceeding in the EU IPO. And that is supposed to take 9 months. You have to add on this about up to 3 months for service upon implementer, which can be in any part of the world. And as a judge, I can tell you this, that also takes time. So on average, you can say it takes 1 year. And during that year, if in parallel, the SEP owner, but also the implementer, brings a case to the court, for example, the UPC, the court is required to suspend proceedings. So 1 year, no effective access to court, delay at the court. When I studied the draft, and there is some some case law cited from the European Court of Justice. And it is true that a mandatory dispute resolution can come before being allowed to bring a case to a court. But in these 2 cases, what is also matters, according to the European Court of Justice, is there should be no substantial delay because of this mandatory dispute resolution. And the one case that was decided, that is cited in the draft, there it was about 1 month. So after 1 month, it was a consumer law case. After 1 month, the person could drop out of the dispute resolution and go to a court. And that was considered to be not a substantial delay. Now, we are talking here about 1 year, and we are talking here about a right that is limited in time. And another aspect which also matters. As you can see now in practice, SEP litigation takes place all over the world. So it can be in jurisdictions in China, in the US, in UK, and in Europe. Currently, the courts of the member states, but also the UPC, just 1 week ago, the UPC issued its first decision in a SEP litigation, which took about 1 year. So at the moment, the courts are really quick and are competitive with the other courts. If the European courts in the future will have to wait 1 year, then the effect will be that the cases will be decided outside the European Union. It will decide in UK, in China, in India, in the US, wherever there is a capable jurisdiction, and there are capable jurisdictions outside Europe. So these are my fears. And just before I stop, what could be the solution from my perspective? Not require the court to suspend litigation while friend determination is pending, but allow proceedings going on and only require the court to decide not before the determination has been ended in the friend determination before the EU IPO. That would give the court the time to develop the case, and then if one of the parties does not accept the result of this dispute resolution in Alicante, then a few months later, then there can be a hearing in a court litigation, and then the UPC and all the other national courts, competent courts in the EU, will not become second-class courts compared to courts in litigation outside the EU. Thanks.
Thank you. I know we're going to pick up, I think, with Andras on some of these questions of, if you like, judicial competition, as it were, jurisdictional competition. Let me come to you, Michael. Opening thoughts. We've heard a lot already, so give us your perspective.
Yeah, I would like to take a step back and to look at it maybe from the bigger picture perspective to start with. So I think maybe to begin with, the patent system is really a catalyst for growth and development. It encourages the emergence of new technologies that help solve some of the world's most greatest challenges. We also know that patents make a significant contribution to our economies. industries that make intensive use of IP rights directly and indirectly support 39% of jobs in the EU. They generate more than 80% of EU exports and contribute to almost half of the EU's GDP. Patents have also shown to contribute to the growth of small and medium-sized enterprises. SMEs that file just one European patent increase their likelihood for future growth by 34%. And startups that file European patents in their early growth stages are around 5 times more likely to secure funding. So we know about the importance of a functioning patent system and its relevance to economic growth and competitiveness. And I think we can say that by and large, the patent system is working rather well. But of course, we also need to be ready to adapt as the landscape evolves, especially if Europe is to secure its competitive future on the global stage. However, I think we must be very careful not to throw the baby out with the bathwater and create complex regulatory environments that stifle rather than encourage innovation. Mario Draghi's recent report on the future of European competitiveness made it very clear that robust intellectual property protection is essential for progress. And President von der Leyen said her Commission's first task would be to create a competitiveness compass to help the EU close its innovation gap with the United States and China, especially in advanced technology. We will put research and innovation, science and technology at the heart of our economy, she said. Mario Draghi also emphasized the need to focus on creating a regulatory ecosystem that's simpler and less complex. And he reiterated what many of us have long understood. Adopting the unitary patent system in all EU member states will reduce costs, provide uniform protection, and bring clarity to patent disputes before the Unified Patent Court. The unitary patent system, launched in June of last year, is off to a very good start. The UPC is up and running, has received, I think, in the meantime, almost 600 cases. And if we look at the unitary patent, the more than 42,000 registered unitary patents demonstrate not only the initial success, but also the growing confidence of users in the single approach to patenting and patent dispute resolution across Europe. And this trust is important. So all of the above should be reinforced by the EU's commitment to simplified and streamlined patent protection and litigation as a key driver to innovation and competitiveness in Europe. The European patent system has proved its worth over the last 50 years and should be relied upon, especially at a time when, after decades of hard work and strong political support from various European institutions, it has finally been completed with the unitary patent and the UPC. And yet, we are faced with legislative proposals from the European Commission on standard essential patents, but also on supplementary protection certificates, let's not forget about those, that run counter to this very objective. So in its efforts to close Europe's innovation gap, the Commission has put forward proposals that create redundant structures, bureaucracy, and add layers of complexity and cost. And this undermines the efforts to achieve a harmonized, streamlined system. It raises legal uncertainty, creates overlapping jurisdictions, and at the end impacts confidence. The proposals on SEPs and SPCs create a disconnect between the needs the UPC precisely was designed to meet and the confidence of those who rely on it. So this is not the unified, consistent approach that users have been asking for. They need clarity, simplicity, and legal certainty, not incoherence. So where to go from here? I think the right thing to do would be to reconsider the whole package, to rely as much as possible on the existing, well-established institutions in the respective areas of expertise and competence, and in particular, not to undermine the UPC that we have worked so hard to establish. And when I say the UPC, I also mean its inbuilt patent mediation and arbitration center. In this way, the stated objectives of the regulation could still be achieved, but in a much more effective, harmonized and streamlined way, and also probably with much milder means. This is in the interest of an efficient and reliable European patent system that fosters innovation and serves all of its users, whether they implement or own patented technologies.
Thank you. Andres, we will turn to you. Thank you for your patience. We've heard from the panelists here in the room, so quite a lot to unpack. So I'll give you a bit of time to give me your opening thoughts as well as a brief reaction to what you've heard.
Thank you so much, and hello everyone. I'm a little bit of an odd one out in this crowd, not only because I'm participating only online, but also because I'm not speaking on behalf of a European organization. So I work for the World Intellectual Property Organization, so our perspective is naturally a little bit different, and I'm not even in the position to comment on any national or regional regulatory initiatives. But we are observing and monitoring all the developments, not only in Europe, but also in other parts of the world with great interest, because we also need to make up our minds as an international organization with 193 member states, where to go on behalf of WIPO, what to do on behalf of WIPO, this global organization, this neutral organization in this field where there is so much to unpack, as you said. If you look at the whole issue through a bird's eye perspective, when you see the different policy thought processes or initiatives, it's always interesting to see that certain avenues are thinking about the whole SEP ecosystem as something that is working very well. It works like a little bit of a roundabout where you don't really need traffic lights. And the other approach, of course, is the opposite, saying that no, we actually need traffic lights, maybe even policemen here, because this intersection of patent law, technology, and some other areas of law, such as competition law, civil law, and so forth, do require some kind of a deeper intervention from the regulator. But if we take a look at what each and every jurisdiction is doing in the standard essential patents area, we do see that the policy discussions and the regulatory initiatives are actually concentrated in very few jurisdictions, and the vast majority of countries do not really have a firm position or even necessarily a good overview of the issue. And this is only partly because litigation is concentrated in only a few jurisdictions. Because in terms of judicial trends, we see something interesting there, because there are some new venues that emerge. India, Brazil, Colombia are just examples where litigation is popping up. So litigation is not only happening anymore in Germany, UK, US, China, and so forth. And even though litigation is not supposed to be the rule here, because the majority of the transactions regarding standard essential patents are not litigated, they are not taking place before courts, or there is no need for court adjudication in the majority of cases, we do see some judicial competition, as some of you have mentioned already, and diverging approaches by the courts in the different jurisdictions. And a very interesting sign of this judicial competition was the emergence of the anti-suit injunctions and the proliferation of the anti-suit injunctions and so forth. In the recent years, this practice seems to be subsiding a little bit, but it hasn't disappeared entirely, and it does create some tension in the patent enforcement system if you take it from a global perspective, because normally there should not be this kind of rivalry between different judiciary authorities. Now, as it crystallized from both the interventions of the previous speakers and from what I said before, it is debated whether there is actually a market failure that needs to be addressed through regulatory measures, or competition law, the self-regulation of standard developing organizations, and certain market mechanisms such as patent pools and others are sufficient to calm down the heavy winds on this sea. And the court proceedings are kind of just the pressure valve to let off the steam if the pressure becomes too high in the system. There are these two approaches, and we do see what is happening in Europe as an interesting experiment. Not only if the regulation gets actually enacted, but also if it does not reach that stage, it will be something that definitely teaches some lessons to everyone. If it operates, we will see how it operates. If it does not get to that stage, then it's a regulatory initiative that shows what the market, what governments, what other stakeholders want and decide in this respect. Transparency has been mentioned several times, and it keeps being mentioned all the time relating to SEPs, but very, very different things are meant by transparency by the different speakers, authors, and other commentators on this issue. As we see it, the main issues around transparency are about the true essentiality, so not even necessarily what has been declared as essential, even though even there are some things to improve, but the essentiality of the actual essentiality of a patent to a certain standard is definitely a little bit of an obscure field, and it does need individual checking all the time. And through what mechanism this is done or this should be done is, of course, debated. And the true meaning of what friend is in a given context is also something that is heavily debated. There is an overall agreement on it should be friend, it should be fair, reasonable, and non-discriminatory. But what these terms actually mean is always up for debate, and it's always very interesting to observe what arguments the different parties are coming up with, and how the courts or ADR mechanisms are actually resolving these matters. So, in conclusion of my my opening remarks, WIPO has consulted a wide range of stakeholders and also member state delegations, and came up with an SEP strategy this year. It was published in April, but this strategy is guided by the principles of neutrality, voluntary nature, and very importantly, a complementary nature of the strategy, meaning that it does not impinge or encroach on anything that national or regional organizations and governments are coming up with. But I stop here, and maybe later I can expand a little bit on what the strategy is trying to achieve. Thanks.
Thanks, Andres. Now, I know we're going to unpack some of what Andres is saying, and we'll give you a chance to give your definitions of friend, should you wish. But let me, Marcus, let me turn to you, because he mentioned the Commission is not in the business of just trying out interesting experiments. So perhaps you'd like to react a little bit on how your focus should be on getting things to work in practice.
Well, I would like just to briefly comment on my co-panelist's comment that the preceding to the regulation, the Commission has carried out vast consultations with stakeholders, other institutions, experts. And these issues, like on transparency, essentiality, ownership, issues of protracted negotiations and costly litigation, have come up and have been reported, or stakeholders agree that there lies the problems. We have also consulted SMEs. It might have been the case that there are not so that the response have not been very numerous in hundreds of SMEs, but still it gives a picture that the problem that SMEs face is that this lack of transparency in particular affects SMEs that then not knowing their exposure do not even take up the latest technology, saying that we don't know how much it costs, we don't know how many more SMEs SEP holders are there outside. We just leave the technology outside and just carry on with the development as we have. And this cannot be the right solution, just to ignore the fact that lack of transparency hinders in innovation in the field. And I also cannot believe that lack of transparency is something that SEP holder wish when some of them say that there should be no regulation in the first place. And the friend determination process clearly aims at limiting the costs of obtaining a license without the necessity of litigation. And the process has been created in a way to have the least possible delay in access to court. And the regulation also requires that the friend determination only is initiated before court action can be brought. So there can be parallel proceedings, and the court then can only
suspended. That's also part of the so you can initiate, but then you put the file aside. That's what the draft say.
Cannot decide on the merits of the case before the friend.
They have to suspend. That's the wording. Proceedings.
Yes, but in the regulation says that the court cannot take a decision on the merits of the case, on the friend issue, if you so will. So in the end, as you suggested, the court can prepare the case in advance, and then once the final friend determination is there, the court can resume the proceedings. So with the regulation is set up that it creates the necessary transparency with the register and the database. It does not aim to duplicate existing registers, but to bring together the information that is needed for SEP licensing negotiations, because there are different registers out there. They serve different purposes. And it is not at all easy for stakeholders, implementers, to navigate through these registers. Although I know that the EPO has linkages with the ETSI database, having a centralized database register will serve the purposes for SEP negotiation better. The essentiality assessment will bring, or is supposed to bring, clarity into the question of essentiality, together with the friend determination, that will help negotiations by the parties that have only the resort to litigation in reality, and with this friend determination process, that will have a structured negotiation assisted by a conciliator, by someone who has knowledge and expertise, and this friend determination will have some, I would say, a significant way in determining what is true friend rate. And in the end, the regulation also foresees some support mechanism in particular for SMEs, to help them navigate through the landscape, to help those companies that are on the receiving or the shorter end of the stick.
Adrian, you wanted to come in, and Marcus, I'm going to come to you next as well. So. Yeah.
So I completely agree with on the whole goal of the thing. I mean, we want to make it more transparent, so information is more accessible for SMEs when it comes to SEPs, agile and less costly. And then when you see to the Commission proposals, you start looking who is going to do all of that, and it's EUIPO. So I was lucky enough previous mandate to also be the chair of the jury committee. So we were in charge of the EUIPO relations. So I went there many times, almost every 6 months. So when I read this SEPs regulation, I said, okay, let's go to Alicante. How are they gonna do it? And I went there. They didn't know where to start, but it's true that they had a very good attitude that we can handle it. And that's important because I believe I believe in the IPO a lot. I defended them, for instance, to get the IGPs when it comes to rural issues, and I think, and they learned, and they built up on staff. They took them 2 years, they could do the job. When it comes to this, they didn't have anything. How are we going to start doing this? So when we want to do more transparent and accessible information, I think the IPO will do a great job, because as you said, they could centralize data much better, and that will help a lot SMEs, I agree. But then we go to essentiality checks, which actually is going to be an extra administrative layer for SMEs. Costly. We are not reducing the price. We are increasing the price. Let me finish, Marcus. So we put an essentiality check that companies that are owners of SEPs, I'm sure that whatever the IPO says that, they're going to end up in litigation regardless. So they're going to end up in litigation, yes. And then we go then to the litigation process. Then we are not, again, reducing costs. We are actually increasing them. And with what the judge said when it comes to the suspension of the file, because it's open, but it's suspended. We all know how courts work. So then we are already killing three of the purposes of the piece of legislation. And then who is going to do the analysis to be essential? Because you need experts. And then they say, yes, and then I asked the IPO, so you're going to hire experts? Saying, no, we don't have that capacity to do a full-fledged department on this, but we are going to borrow the experts from the National Patents Agency, that Michael, I'm sure, could actually give us more information on this. And I said, how are you going to pay that? How are you going to structurize that within the European Union? So you're going to hire people from Romania, France, Spain, depending on where the company is. How are you going to structurize the salaries? This is a really important question. How are you going to actually handle that kind of hands, of work? So what I see again is that, yes, on paper, I agree. More transparent, more agile, less costly. But then you see what are the proposals, and I don't know if any in the Commission, I'm sure you did that, went to the IPO to talk with them. Can you do this in a really professional and less costly way? And they didn't convince me. They did not convince me.
Marcus, your thoughts? No, I'm sorry. You can take an answer there if you want to on what you're hearing. I'm sure you want to push back a little bit.
Yeah, sure. So we talked to the IPO, yes, and their role is more an administrative role. So they are not going to hire people. They are not going to decide as an agency. They will just manage the process. There will be the tertiary legislation that will set out the details of this process, but they will manage a roster of experts that will come from various places, not necessarily from the patent offices. But all can be patent attorneys. In the impact assessment, we have made a calculation on the potential number of available experts, and we think that there are sufficiently people out there. So this is all that the EUIPO is going to do, and in the end, what the system is about or requires, the transparency which comes primarily from SEP holders, because they have the information. They know, or should know at least, which of the patents in the portfolio are SEPs, which of them are really essential, and what the friend rate would be. All this information now is either not there, it's hidden behind NDAs, whether it's justified or not, and so the regulation requires basically from the patent holders what they are basically should do.
Michael, you're a bit a step removed from this disagreement. So give us your perspective, your thoughts.
Well, I would like to go back to the UPC again.
Okay.
Maybe not really look into the nitty-gritty. I think I agree very much with what Adrian mentioned, and I fully subscribe to that, and I could echo that almost word by word. But there's certainly a question where all these experts should be coming from. Many of those are probably well employed and are not just waiting for someone to show up and come with another job offer that they may or may not like to consider.
Although living in Alicante is amazing.
Living in Alicante is amazing, yeah.
Great place to go.
Yeah, I'm sure it's not the worst of all places in the world. But I think, looking again at what we have and what we have worked so hard to build in the context of our European patent system. For decades, we have invested so much work and political support to complete the missing link of the European patent system by creating the unitary patent system, by creating unitary patent protection, and by creating this fantastic new court, which will enable Europe-wide settlement of disputes in patent matters. The UPC was really created as a supranational court with highly experienced judges and tailor-made rules of procedure. And why did we do this? Because users demanded it. They knew that this specialized court was the key to providing Europe-wide certainty and consistency and coherence in the innovation landscape, overcoming the fragmentation. It's the involvement of some of the most experienced national judges that sets the UPC apart. And that's a feature that simply wouldn't have existed if patent litigation had been handed over to the EU General Court in Luxembourg, as the Commission originally envisaged. So I have the feeling we're just going a step back again. So again, also imposing a mandatory 9-month conciliation period for SEP disputes, which I agree with Klaus, is a significant barrier to access to justice. That would delay the initiation of any court proceedings within the EU, including before the UPC, of course. And yes, those would drive cases outside of Europe. People would just go elsewhere with their cases. And these are some of the most valuable cases that we have in Europe. It would also significantly reduce the scope for voluntary alternative dispute resolution before the UPC's Patent Mediation Arbitration Center, leaving little or no room for mediation within its framework. And this means that the UPC's competitive position in patent litigation would suffer, and that cannot be in anyone's interest. So I think really it would make much more sense to rely on the UPC and its built-in Patent Mediation Arbitration Center, the PMAC. The PMAC will have the necessary expertise to deal with complex patent issues, and compared to all existing arbitration and mediation mechanisms, the role of the PMAC is quite unique because it's built in, it has a statutory link to the UPC. I think no other arbitration and mediation offering has such a statutory link to a court. And because of this link, the PMAC will be dealing with SEP cases in any event in the context of pending litigation. So you will have expertise there. For instance, if a party to an infringement case raises a friend defense, the UPC judge can ask the parties to refer the friend part of the case to the PMAC for mediation. There are also articles around that are looking at this issue, and I think some interesting findings with this regard. But also, irrespective of any pending litigation, parties can go to the PMAC to reach friend agreement. And to be clear, the PMAC is not only open to parties from the participating UPC member states, anyone can go there. And also the scope of the dispute can be much broader beyond the jurisdiction of the UPC. Let me maybe just, before concluding, say one thing, and I would like to refer to an interview from the president of the PMAC, Ales Jala, who has been appointed recently. And he has made a point that the PMAC can play an important role in SEP litigation and friend issues, and that friend has been on his mind when drafting the PMAC's rules of procedure, which are currently being finalized. So to have procedures that are specifically adapted to friend disputes. So rely really on the existing institutions in their respective areas of competence. SEP mediation in the PMAC would be much more appropriate than any compulsory mediation in the EU IPO which violates potentially fundamental rights and access to justice and produces at the end just a non-binding result that will be challenged in court anyhow.
Andres, I know you want to come in as well to add a note on the WIPO approach.
Yeah, exactly. And I don't want to actually distract the conversation. I just wanted to add to what Michael was saying about the PMAC, that WIPO also has an ADR venue, the Arbitration and Mediation Center. Obviously, it has a global reach. It's also open to any clients. And I'm not trying to create rivalry with the PMAC. It's rather just to highlight that that there is that opportunity as well, both arbitration and mediation, and also additionally expert determination. That is also a very versatile and flexible tool for just maybe separating the friend issues in one particular dispute and submit it to alternative dispute resolution. And in addition to that, there is also a functionality called deal facilitation that is essentially mediation without actually a legal dispute, where the negotiating parties that are in the process of creating a license agreement in the SEP field and also in other fields, but the SEP is an area of focus for the Arbitration and Mediation Center as well. They can do that. They can force that deal in the presence of a neutral third party furnished by the Arbitration and Mediation Center. And this actually constitutes the third pillar. I mean, all these services of the AMC are constituting the third pillar of WIPO's SEP strategy. So I just wanted to add that point at this time. Thanks.
Well, I wanted to pick up on this question raised by both of you, a little bit of, if you like, jurisdictional competition and the actual practical implications of cases going outside Europe and what that might mean if we see that happening. I mean, we talk a lot about, sovereignty, security. What does that mean in terms of national security defense capabilities in this sector if Europe is falling behind? Klaus, do you have any thoughts on where we stand on the global scale?
I think at the moment we are doing pretty well. European courts I use again the word which normally you should not use in relation to courts, are competitive with regard to other jurisdictions in the world. The antitrust and the anti-antitrust, which actually was developed in German courts. Now this case has been brought to the WTO, and we don't see this any longer. So that is a good development. Essentially, we at the moment the infringement aspect of a case is a national one, because a patent is national, or a unitary patent is a patent of some countries. But the friend aspect is an international one, it's a global one by nature, at least in many industries like telecommunication and so on. And so there is a situation that you have different jurisdiction where this case is coming up, and then which jurisdiction is deciding this at the end. Well, coming back to the draft, I don't know whether this is really putting Europe in a better position with regard to other jurisdictions, but these cases always can be brought. Of course, the EU can only make it mandatory for the EU territory and not beyond that. And that is really a question that has not been addressed, to my understanding. I haven't read much about this. So what is the position there? Where is the advantage in comparison to other jurisdictions? Will it delay? Or is there really an advantage? I don't see the advantage at the moment. And maybe that's also a question for the Commission to answer. Where is there the advantage of the European system? Because at the end, there is one who decides the case at the end of the day on a global basis. And for example, I hear Chinese, I had conversation with Chinese judges, and the Chinese say, okay, it should be decided by the court where's the biggest share of the market. And guess where it is? So I would be really interested, what is the position of the Commission? What is the benefit of this system if you look at this from a global perspective?
Before I let you answer that, Marcus, Klaus, I'd like to know your thoughts on what you think are the key determining factors. Is it speed? Is it cost?
Speed is definitely a factor, because when the first judgment is out, it is out. And of course, the question is, does the court have jurisdiction also with regard to this global aspect? The UK courts say yes. There is at the moment no decision from European courts in that respect. But of course, it goes along the line of the idea that normally a license should be set according to the conditions. A license would be set, and in the context of telecommunication, of course, it's global. A license for a country or for a region is of no use, obviously. So it has a global aspect, and normally it's the first court who decides who decides the case at the end of the day, and that's why it is so important that there should be no delay. And please, when you say you give it, may I come back to the suspension aspect? It's interesting to hear. Normally, I would say suspension is stay. If the Commission takes another view on this, then please do this before it's becoming law. Be clear on this. Be transparent on this. That is something I would like you to invite. Because don't leave it to the judges when you use a word suspension, which has a certain significance in the legal world.
So, Marcus, I will let you come to this, and I'm also going to ask you to dovetail it with a question from our audience. Federico Dante Del Falco is asking you, is the EC worried that the regulation may incentivise holdout practices during the 9 months FRAND determination, especially in light of recent market developments?
Which should I reply to
I am
first?
allowing you the freedom to. They're both tough questions, so as you wish.
So I just start with the problem which we have, that in the European courts do not decide on FRAND terms, and in my view, what makes other jurisdictions interesting, UK or China, is that actually courts set FRAND rates, and the interest is there, and cases will be brought there. If we have an international companies, they can choose wherever they want to go. This is clear. So here, what we have decided to have a soft approach, to allow parties to negotiate and to arrive at the FRAND terms without litigation, and. Of course, it's the court action is or decision of a court should be possible only after the FRAND determination has terminated. But it's still, in my view, faster, taking into account also the time that is being used on negotiation. Than any litigation, because we have currently a situation where negotiations start to take several years, and after failed negotiations, then litigation starts, and the FRAND determination can set in any time during the negotiations when the parties say everything is pretty much clear apart from the fact of the FRAND rate. So let's have a resource to FRAND determination, because in any event we would have to go through it. So it will discipline parties. It will shorten the negotiation time.
Of this FRAND determination, one of the parties can say no. And that's it. You cannot say no to a judgment. I think that's a fundamental difference between arbitration and litigation.
A party can say no to the negotiation result even without. So it's on both sides. The FRAND determination, coming to the question from the audience, I think that the FRAND determination result will serve in a ensuing court procedure as for the court as an indication for, let's say, a security payment. So after FRAND determination, the implementer knows more or less how much it would have to pay, and this would rather disincentivize holdout, because it knows how much it has to pay. So in the end, the court might decide on a security much faster and on the basis of the FRAND determination.
Another quick audience question before we go to a final round of wrap-up already. A question from MLEX, Adrian, to you, asking whether you could expand on how the SEP regulation might impact businesses outside of Europe.
Well, first of all, it's going to impact European companies with SEPs outside of Europe. And when it comes to the kind of technology that SEPs is protecting, obviously this is a weak spot for us. And this is not only worry to us, but it worries to allies of us, like the US. They are really worried about this relation going forward because how this could impact those issues. When it comes to how it will, I think that is a dead piece of legislation. And while I also believe, and here I'm with Marcus, that there was enough reasons enough to do something and try to make it more agile, less costly, more transparent, I think we have missed an opportunity. And that's, for me, is the biggest problem, because I've been working in a file for 1 year, and now it's going to be blocked, who knows for how long. So how will it impact? I think is that. So this is not going to go forward, which I think is good, because it's not a good piece of legislation. But the question now is what the Commission is going to do with this. So I really, to talk about how it will is just, talking about the future. I don't think it will happen.
Well, we're going to wrap up. So, Marcus, this is your final takeaway remark. So feel free to sum up, if you can, everything you need to say in 2 minutes. Easy.
When it comes to the legislative process, the ball is now in the court of the Council. Obviously, the last presidencies have not discussed the SEP proposal, because there were other files that were equally or perhaps even more important. For the presidencies, now the Council has to move forward, has to adopt a general approach, and then we can discuss the regulation and trilogues with the Parliament and the Council, and there are still ways to find an agreement. We have, of course, taken on board comments that we have received throughout the years, also following the adoption, and also following the adoption in the Parliament. And I think we are well equipped for a fruitful negotiation in the trilogues that hopefully will come anytime soon.
Time will tell. Andras, your final thoughts to wrap up our discussion for the panel.
Thank you for giving me this opportunity. Let me then just highlight something that is more than promotion. It's actually very useful pieces of information that we are already putting out under the second pillar, which is WIPO being a source of knowledge and information. We already have a pilot version of the WIPO Lex SEP case law collection online, available to everyone, and that creates a good library of noteworthy decisions, of course, around the world in this matter. And we are also working on an interesting functionality in the patent scope database that I think everybody here knows already. There will be a new tab at those patent records that are affected by an essentiality declaration at one of the SDOs that we are collaborating with. And watch this space, because we are also going to come out with some economic studies on various aspects of FRIEND. First one being an overview of the methodologies that are being used from an economic perspective. So in terms of teaser, this is all what I need to say, but stay tuned.
Thank you, Andras, and thank you for being with us in spirit and in voice, if not in person. Let me turn, Michael, your final brief remarks to finalize your position.
I'll start with a quote from Executive Vice President and Commissioner responsible for tech sovereignty, security and democracy, Ms. Virkkunen, who warned before her appointment as commissioner in her capacity as an MEP that reducing patent protection will increase risks, as will discourage European companies from participating in the development of global standards by undermining patent protection and said that the regulation can have negative impacts on Europe's competitiveness. So I think we, as I said in my introductory remarks, we really need to be careful not to throw out the baby with the bathwater and to reconsider relying on the expertise where it sits and again building on the institutions that we've worked so long to establish, the UPC and the Patent Mediation and Arbitration Center.
Adrian, you've said you feel a bit disappointed, but there's still work ahead. What are you looking forward to in the next steps?
Well, I think that we all agree on the why, that there is a strong why we had to explore options to improve the SEP situation. I have doubts on the who, to whom it was really addressed, and we still have a lot of doubts or questions on how we can actually improve what we really need to improve.
And naturally, I give the last word to the judge.
Thanks a lot. So, I was really interested in the discussion how, if it's entering into force, how it will be that setting up of the respective bodies in Alicante. And I felt remembered a bit of my court, because it's also a startup, and what effort it took to get this all up and running. And I think there are a few elements that at the end of the day, even though the court is not mandatory, you can opt out from the court's jurisdiction. At least seems to me to be quite a success for the time being. And there is, I think, one essential reason that most of the judges that are currently with the UPC, people knew these judges already from the national jurisdictions. And so they had confidence in the court. And I really wonder what is going to happen in Alicante. Who are these people? Okay, you identified them with theoretical means. That's wonderful. But I really want to know who these people are. And then secondly, who is controlling these people? How to exclude that the examiner, or how are these people called? So you deciding, making a suggestion to the left and to the right. And who is taking care that in all this respect, EU law is applied in the determination that is out of the control of the CJEU? And another question that crossed my mind when I heard about the essentiality test. When you read the decisions of the CJEU that deal with European patents, and SEPs are European patents, the European Court of Justice always avoided to apply the European Patent Convention because it's not EU law. Now, when you do the essentiality tests, you first have to interpret the patent claim, otherwise it doesn't work. And interpreting the patent claim for European patent, you apply the European Patent Convention. So then, is it then the agency in Alicante, EU agency, that is applying European Patent Convention, not EU law? And then, is this then controlled at the end of the day by the European Court of Justice? How does this work? So I'm also a bit worried who is controlling this new agency if it is up and running. So that is another concern also from a judicial perspective.
Well, uncharacteristically finishing with an open question. Thank you very much to the panel. Do stay with us. In just a moment, we will be hearing from one of the companies impacted. Patrick Hopkins, Head of IPR Policy at Ericsson, will join us. But please, let's have a round of applause for our panel.
Thank you.
Thank you.
Thank you. Thanks.
Podium. Podium. Oh, they've lost it. Patrick, why don't you join me here? Patrick, just join me here.
Richard is bringing it, so...
We've got it.
Yeah, I'm going to go back down. Sorry.
So I am standing between you and lunch, and so I'll try to be short. I thought this was a super interesting exchange. Since first starting working on the SEP regulation, I think it was March 2023, there's a lot of discussions that took place, and I think today again has confirmed that having done the detailed analysis, worrying a lot about how this regulation can actually become operational, let alone functional, I think what today again emphasized is that you, before going into these technical and complex issues that still need to be resolved, there is still an absolute need to take the higher ground and to look at some higher level topics. And one is competitiveness, been mentioned by a lot of speakers, and I think it's a super important topic on different levels. You have, of course, the competitiveness in the standardization effort itself. When we look at our most important trading partners, you do realize, and you do very quickly see that over the last couple of years, these most important trading partners, China, US, India recently as well, and indeed Brazil is coming and Colombia. But looking at these three top, they have all focused on standardization strategies. They have all made very clear plans how to get standardization much more higher up on the agenda in one particular way, which is incentivizing companies to participate in standardization, incentivizing academics to participate. The SEP regulation mentions that as well, but there are no concrete measures. There is nothing concrete there to incentivize participating in standardization. On the contrary, there is more burden and more costs. So I think that's a very important point, taking a step back. Competitiveness, we heard it in the interaction, is also relating to jurisdictions. I know we can't say it, but there's a reality that the European courts have over the years been very influential in setting guideposts, because I think what is underestimated, and what was underestimated in some of the interventions, is the importance of transparency provided by courts, courts setting guidance, courts setting a framework of how to negotiate, how to really discuss these things. And that level of transparency is not to be underestimated, and it's important that that is done in a very qualitative manner, which is another point I think when we talk about competitiveness of our legal system that is important to underline. The second big topic that was discussed a lot is the institutional one. And it is indeed relatively strange with Draghi, Letta, and the competitiveness compass in our hands to realize that after 70 years of working and harmonizing the unitary patent system, the first patent package actually goes very quickly to try to destabilize that entire effort. And you can say it's non-binding, etc. The reality is that if it's non-binding, that raises the following question. The UPC today is starting to work in the SEP context, are having the first SEP cases. By the time that this regulation will see the light of day and becomes operational, I think the UPC will have taken a lot more steps in basically giving guidance to the market on SEP regulations. And two things can happen. Either the FRAND determination that is non-binding follows the UPC, in which case you wonder, do you really need that mandatory level? Because courts are very well equipped to say, if they feel parties can actually come together to force parties to go into mediation. So do you really need a mandatory mediation if there is just a following of what will come? And if the FRAND determination would not follow the UPC, then we're back to the first comment, which is this will basically unravel and undo 70 years of work of trying to harmonize. So in both cases, I don't fully understand the added value that is being brought by the FRAND determination. So that's the institutional level, I think, which is a very important one. And also, again, in Draghi and the competence compass, I think the courts and the UPC play an incredibly important role to create a strong IP system that can help get investments flowing more to Europe. Last point is more the technical points that were mentioned. And one, of course, that everybody mentioned was transparency. And the transparency, I think somebody said it, and I think it's an absolute good point. Transparency means different things to different companies. That is absolutely very important to underline. Second point, 2017, the Commission recognized that there is no one size fits all. On transparency, that is absolutely the case. You need to look at the SDO in particular to understand what is it that can help transparency for this particular standard. There are standards with tens of thousands of patent families, where with the biggest companies in the world, when you negotiate, you bring a couple of hundreds of claim-chartered families to the table. You have detailed technical discussions for months on these couple of hundreds representative, qualitative claim charts. You do not go to every individual patent or every individual corner of the standard. Yet the regulation has this whole list of registration that provides information on information. And I think when we talk about transparency, we really need to be careful. Transparency is not helped by more information. More information can actually kill the informative nature of the information. And I'm afraid that we are, not super clear on what exactly we mean when we're talking about transparency, and that's important. When I look at transparency, I look at the market, and I follow Richard, and that's, the beginning meeting the end, that indeed in the cellular standard, there are so many reference points that exist today that it is very hard to make the point that there is no transparency. The NDA argument is being used so often. It's not a correct argument. When we have negotiations, we find a way to go about that one. We have a way to present claim charts, to present benchmarks, to present reference points. So transparency in the cellular space, I think, is absolutely there, and it's not correct that it's not there. There is indeed competition, and there is indeed further discussions, but I think precisely these reference points created by the courts are the way to go forward, to try to find a system that can actually evolve indeed further, and that basically is beneficial to the good faith actors and does not create a regulatory overburden that actually will benefit bad faith actors. I think that is really the risk that we should look into. And I think that summarizes a little bit most of the points were said, and I was very pleased to be part of it. Thank you very much, Qualcomm, for inviting me, and thank you very much.
Thank you very much, Patrick, and indeed all our speakers, and to you, the audience, for joining us today. And that is a wrap for this Euractiv debate. Thank you for joining the hybrid conference. You can find more information on Euractiv debates at events.euractiv.com, and we hope to see you again soon. Have a great day.